People versus Brenda Miles Roberts.
Again, good morning, Your Honor. Robin McCoy on behalf of Miss Brenda Miles Roberts, who stands to my right.
Your name again?
Miles Roberts.
Thank you. All right. Good. You had read the pre-sentence report, no material deletions, corrections, or additions. Anything two of you'd like to say before I propose sentence?
Yes, Your Honor, just by way of explanation. So my client is gainfully employed. She also has her own separate home care business. This is her first time ever having a drunk driving situation. So she's very remorseful about it. Her mother passed away on June 30th. So that she had been grieving and had time off of work. I did notice the violations, and she had explained that for the July 30th violation, her daughter was going for her first college to go to Wilberforce. So that she said August 4th was her first day back to work. I would note that all the testing that she did was resulting in negative testing results. As far as the payment, she said she'll need till Friday to make that payment of the $264 because that's when she gets paid. Okay. Oh, she's saying she can pay $120 today. I did notice that there was the order recommending. Let's see, it's the violation order. And it said that there would comply with the order 3 times a day. I would just note for the court that this is her first time having this offense, doesn't have a history. She was out with a friend, and she said she was at the light and the person came out of nowhere. And so we're requesting that we abide by the report, but we are requesting that she be given the opportunity to, if not, or just discontinue with the sober link, or at least have a reduced time, come back after she's had a period of compliance and come off the sober link. We also provided a verification that she did comply with for the MAD, the Mothers Against Drunk Driving class, and the sober link listing, which we emailed to the court in this Pilar. So, and did you want to say something to the court? She does want to say something to the court.
Yeah, the time I was wondering for the times that they were saying that I missed. I'm going through a lot right now.
I read the report. I'm not concerned.
Oh, okay. I just wanted to make sure because I just went back to work and I work in the doctor's office. It's kind of hard to be going back. I can be I'm a surgical assistant. So if I'm in surgery and my alarm go off that I got to blow, once I get out of surgery, I might forget. It's just too much. If it was something different, I do, but I can't, that blow thing I got a lot going on with working in a doctor's office. And that was it. I just wanted to let you know that I'm going through a lot right now. I'm going to grieving too about my mom with my insurance company, my medical insurance and everything. So there's a lot going on in my life right now. Besides all of this, there's a lot going on.
And how's your daughter doing in college?
She's doing great and she's loving it. And I'm really alone now because it was just me and my mom. So my mom gone, it's just my daughter gone. So it's just me.
Yes, Teresa Claire on behalf of probation. Your Honor, I just wanted to let the court know that Ms. Miles Roberts was scheduled for sentencing earlier. My office had to bump that out because there was a possible restitution claim. So she kind of already has gone on the sober link for an extended period of time because I did have to adjourn that for a possible restitution issue. I never received any follow-up from what was initially sent. So therefore, there's no restitution recommended.
Got it.
Okay, but I just wanted the court to be aware
that she was on it.
An extension of time because it had to be adjourned to hash out and see what was going on with restitution.
Got it. Court does acknowledge this is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of early intervention in educational programming, attendance at AA meetings, and abstinence from all intoxicants. The court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. So therefore, the sentence of the court, you're placed on probation for a period of 12 months. You are to pay $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $360 probation oversight fees. You're to pay $120 today, and then a payment plan as arranged by probation. You understand that, ma'am?
Yes, I do.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the alcohol highway safety education program. You are to attend one AA meeting per week for a period of 6 weeks with verification to probation. You are to provide proof, and I think you have, of the victim's impact panel attendance to probation. How much longer was she on that sober link, Miss Clara? Do you have a calculation of days?
Let me see.
A month.
So her original sentencing was,
July 8th
yes, July 8th. And it was set for,
today. So it's been longer than the 30 days. All right. I will indicate that she moved from the sober link, so the sober link will be discontinued. She's already done what I would ask be done.
Thank you, Your Honor.
All order 93 days in jail. Credit 1, the balance is sustained. Thanks.
Thank you. Thank you, Your Honor. I hope you and everybody has a great day.
hi, good morning.
Perfect timing. We're done with that block.
Oh, great.
Yeah. So nice you to stay, but we gotta go. Court stands in recess.
All right.
Attorney on behalf of Mr. Brown. Mr. Brown, state your name for the record, please.
Brown.
Thank you.
So this is a show cause for money owed on an old case. Seeing as Mr. Brown is in custody, I'd ask for an adjournment.
You're brilliant. No, come there.
Sorry, I didn't hear you.
I said, when you said he's in custody, I said, oh, you're brilliant. No, I'm coming after the how much is it?
I have 440.
How long have you been in?
About 40 days.
Is there some of it? What do you have?
I'm here. I have a year sentence here. I've told you that. Well, I told my lawyer I had a year sentence here, so I'm gonna be here until April. I didn't procure the money when the last time I came. You told me to come and pay. I think like 100 or something. I didn't procure the funds before I came, so I didn't know I was not going to be able to pay the rest of it.
I'm going to waive all the fines and costs except the statutory fees. You're all set. Good luck to you and me. Court calls the case. People versus Michael Naparella.
Good morning. This is hearing on behalf of Mr. Navarala, who is in custody in the Ohio Department of Correction.
Your Honor, I can confirm that he is in custody in Ohio. Given that he's not present, I would ask the court to adjourn this out to September 23rd with a writ being done to the Ohio facility.
I'll adjourn this out to, you want the late September date or the October date?
The late September date, I think, would be sufficient.
September 23rd, 2026. Is that at noon or 9? 9 a.m. There was only one on, correct? Court calls case People versus Jason Haas.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Haas. State your name for the record, please, sir.
Jason Haas.
We did review the sentence recommendation in this case. We ask that you adopt it.
Sir, anything you want to tell the court before I impose sentence?
Just that I'm realized the wrong and working on myself. I'm gonna do better from now on.
Court acknowledges that this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. Therefore, the sentence of the court, I will place you on probation for a period of 24 months. You are to pay $1,255 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $720 probation oversight fees. When do you think you can get that paid, sir?
Well, after this, I'm gonna go to another county. They want to give me a year.
Pardon?
I'm gonna go to Livingston County after this, and they want to give me a year cap for a UDAA. So I don't know how it's gonna work, sir.
Now listen closely, because this is where probation gets complicated. He's receiving a 24-month probation sentence here, but he says another county may sentence him to a year on a separate case. Instead of pretending those circumstances don't exist, the judge sets a payment deadline and explains that they'll figure out his situation later. That's a good example of judicial discretion in action, setting enforceable conditions while leaving room for circumstances that may change. But with another case waiting in the wings, his legal situation is clearly far from
Okay.
over.
Here's what I'll do. I'll just indicate that it's to be paid by December 31st, 2026, and then we'll figure out where you are at that point.
Yes, sir.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll report to community corrections within 24 hours to begin weekly random testing. I'll do it this way. If he's going to Livingston, you have to report to community corrections within 24 hours of release.
From Livingston?
Right.
Yes, sir.
You're to complete outpatient substance abuse treatment, including all recommended aftercare with status reports to probation. You're to attend one AA meeting per week with verification to probation. Provide proof of victims impact panel attendance to probation. On order 365 days in jail. Credit 27. The balance on this case is suspended.
Thank you, Your Honor.
Thank you.
Oh, man, let's use the.
I'll watch the thing.
Court calls case People versus Kimberly Bronson.
Good morning, Assistant Public Defender Lauren Perny on behalf of Miss Bronson, who's in custody at the Wayne County Jail.
And Teresa Flair on behalf of probation and your honor. I did confirm that Ms. Bronson, she left our facility and was transferred over to Wayne. So she is there. Probation's asking for an adjournment for writ, in that case. Not opposed to September 20th or the 1st October date.
What I'll do is I'll then adjourn this matter to September 23rd, 2026, 9 a.m. What are you doing, Buckovich?
Wait for my case to be called.
No, I was asking, we missed you when we started. And we asked Miss Perrine where you were. And oh my God, her response. I'll let her tell you. She should tell on herself. It was very non-Perrine. Court calls the case, People versus Theory Reynolds.
Good. Assistant Public Defender Lauren Perry on behalf of Mr. Reynolds, who is approaching. State your name for the record when you get to the podium, please, sir.
Theory Reynolds, good morning, Your
Good
Honor.
morning, sir.
Your Honor, Mr. Reynolds is also in custody. This is a show cause for money owed. I'd ask for an adjournment of the show cause.
It's the
How long have you been?
410 owed. How long, what are you in for?
Can I say something, Your Honor?
Stop me, I guess. Go ahead.
So I was in here last year from August until November.
You were in custody, you mean?
Yeah, from August to November I got released, but I had seen you for this apparently, and I was wondering, like, at some point will I be able to like move for like a time served or something? I don't know how much this charge carry or what, but I really don't have no money.
Okay, I know. So how long are you in for right now? What are you in for?
I got a couple charges I'm here for right now. I go to court tomorrow. Actually, I'll see you tomorrow. I'll see you tomorrow.
For me?
Yeah.
What's charged?
Felony.
Well, I know that, but
When did you come to custody?
Uh,
small stuff.
the
5th of this month
5th.
of August.
Are you under sentence on any case?
No, sir.
So you have that case that's with me tomorrow.
Mm-hmm.
Then that's it? That's all you have right now?
Yes, sir.
You still have it up. What's his bond?
My bond on the case tomorrow, Your Honor. Excuse me.
Yeah.
$1 million.
It's $1 million?
Yes, sir.
And this suddenly takes an interesting turn. The judge learns this case involves driving while unlicensed, but the defendant is also facing a separate felony case with a staggering $1 million bond. Importantly, those are separate matters. The bond on the other case isn't the sentence for this one. The judge ultimately chooses to waive most of the fines and costs here, leaving only the statutory fees. That's a significant break financially, especially for someone who says he has no money. Do you think the judge made the right call?
Is driving while unlicensed, which apparently people do. Way to be so no.
It was I allowed somebody.
No, I don't even want to know. Just here's what I'm going to do. I'm going to waive all the fines and costs except the statutory fees, and that way you're done with this.
Your Honor, excuse me. Thank you first for foremost.
You're
Know
welcome.
what the statutory fee is?
I think it's going to be 125. It's going to be 125, but counsel could explain to you about that.
Okay.
Okay, just
Read back up.
All right. Thank you, Your Honor. I appreciate.
you're welcome.
Sorry for speaking too much.
What?
Sorry for speaking too much.
No.
And that brings this courtroom session to a close. We saw several completely different situations. An impaired driving case focused on rehabilitation and compliance, defendants dealing with money owed while in custody, probation requirements stretching across multiple cases, and finally, a defendant receiving substantial financial relief from the court. The common thread is that sentencing isn't always just about the headline offense. Judges have to weigh compliance, finances, rehabilitation, other pending cases, and the practical reality of what a defendant can actually do. But what do you think was the most surprising moment in this hearing? Let us know in the comments. And if you want more real courtroom breakdowns, make sure you're subscribed.